Assalamualaikum and hi. We are from BAC4A and from Group 1. In this video, we are going to explain about the compulsory winding up. Compulsory winding up is a legal process where a court orders the dissolution of a company. This process is initiated through a petition to the court and is governed by a specific legal provision. This typically occurs when the company is unable to continue its operation due to insolvency or other significant reason. So, the reason for compulsory winding up include, according to Sections 465, the court may order the winding up if, first, special resolutions. If the company is self-resolved through a special resolution that it should be wound up by the court, this becomes a valid ground for compulsory winding up. A special resolution typically requires a higher threshold of approval from shareholders. Second, failure to commence business or suspensions of business. If the company has not started its business within a year from its incorporation and if the company has suspended its business for an entire year. Third, inability to pay debts. The company is unable to pay its debt. This is a common ground but can be evidenced by a creditor issuing a statutory demand for payment and the company failing to satisfy it. Fourth, misconduct by directors. The directors have acted in their own interest rather than in interest of the members as a whole or have acted in a manner deemed unfair or unjust to the members. This includes directors using their position to benefit themselves at the expense of the shareholders and any other actions by the director that compromise the fair treatment of shareholders.
Next, we will talk about the legal procedure. Initiating compulsory winding up is number 1. Filing a petition. A winding up petition must be filed with the High Court. The petition can be filed by the company, creditors, contributors, or combination thereof. Number 2. Serving the petition. The petition must be served on the company at its registered office. Notice of the petition must also be advertised in a widely circulation newspaper and the government gazette at least 7 days before hearing. Next is court proceedings. First of all is court hearing. A hearing date is set where the court will consider the petition. The company and the creditors or interested parties may attend the hearing to support or to oppose the petitions. Number 2 is winding up order. If the court is satisfied with the grounds for winding up, it will issue a winding up orders. The court will also appoint an official reserver or a liquidator to oversee the processes. Next is role of liquidator. First of all is taking control. The liquidator takes control of the company's asset, books and records. The director's power keys and the liquidator assume responsibility for winding up the company's affairs. Number 2 is asset realizations. The liquidator collects and realizes the company's asset, ensuring fair distribution to creditors according to the priorities established by the law. And the last one is third, investigation. The liquidators investigate the company's affairs, including any potential misconduct by directors or the officers.
The fourth legal procedure is distribution and dissolution. The liquidator distributes the realized asset to creditors from their creditors' claim. After complete, the liquidator calls for the final meeting and apply to court for dissolve the company. 5 legal procedures, or the last one, post wind up consideration. All documentation must be filled with the SSN and the court, and the director may be disqualified from the board.
Next is the directors, shareholders, and creditors' roles in the winding up process of a company. Directors are crucial in prioritizing the company's and creditors' interests, especially in tough financial times. They manage identifying, protecting, and fairly distributing company assets to ensure creditors are paid properly. Directors follow strict legal duties and work closely with liquidators for a smooth winding up process. Besides, shareholders are key in starting and agreeing to wind up the company. They choose the liquidators who oversee the process and can claim leftover assets after debts are paid. In meetings, they discuss the company's future and how assets should be fairly distributed. Lastly, creditors are focused on protecting their claims against the company's assets. They file claims to document debts owed to them, attend meetings to oversee the process, and ensure their rights are respected throughout the winding up. Monitoring closely, creditors ensure transparency, fairness, and a better chance of recovering what they are owed.
Next is the implications of the company winding up on stakeholder, which is firstly is shareholder. Shareholder may lose some or all of their investment in the company as the assets are typically liquidated to pay off creditors in a prescribed order of priority. Shareholder liability is generally limited to the amount unpaid on their share unless they have given personal guarantees or engaged in fraudulent or wrongful trading. Second, employees. Employees may face immediate termination of their employment as the company ceases operation. Depending on local employment laws and the company's financial situation, employees may be entitled to severance pay or other termination benefits. Third, supplier and customer. Supplier may lose outstanding payments owed by the company and customer may experience disruptions in services or products provided by the company. Contracts with the company may be terminated or affected by the winding up process, leading to potential financial loss or the need to find alternative supplier or customer. And lastly is the creditors. Creditor claims are typically prioritized in a specific order, with secure creditors having priority over insecure creditors. Creditor may recover a portion all of the debts owed to them through the liquidation of the company's assets, though this is often subject to availability of funds.
Alright, next I will explain about the alternatives of winding up. So there are three things to company to do. The first one is restructuring. Under restructuring, there are four things, which is the first one is debt restructuring, operational optimization, equity infusion, and asset realignment. Second process is administration. Administration involves appointing an administrator to manage the company's affairs, business, and property. For example, the owner of the company may selling their business to rescue the company as a going concern. So the third process is receivership. Receivership occurs when the secured creditors appoint a receivership to take control of certain assets of the company. For example, the receiver will sell the assets over which they have control to repay the secured debt. This could potentially restructure the business to make it more viable in the future.
The case Haji Fifi bin Haji Hassan V. Norman, Disney and Yang Sdn Bhd and ours involved Haji Afifi who owns 65% of the share in Norman Disney and Yang Sdn Bhd and DY, an engineering firm in Malaysia. The core issue was the legality of the company's business operations under the Registrations of Engineer Act 1967, which meant that only Malaysian citizens or permanent residents can be professional engineers and hold significant contracts in such firms. The court found that the agreement and structure set by NDY, which effectively allowed foreign contracts by appearing to comply with the law, were illegal from the outset. This arrangement, known as an Alibaba company, was a scheme to circumvent statutory requirement and was against public policy. As the result, the court ordered compulsory winding up of NDY under Section 218, Subsection 1, Subsection F, and Subsection I of the Companies Act 1965, emphasizing the necessity of terminating the illegal business operations to uphold legal and ethical standards. you.